Good morning.
Good morning.
Good morning.
So we are here this morning um, in the matter of Balboa Capital versus Making Away 7 LLC and Jeffrey, is it Body, sir?
Bodie, man.
Bodie. Okay, thank you. Um, so it's actually the case is actually before the court today um on a default calendar. As I review the record, my understanding is that this lawsuit was filed back in July. Service was secured in August. It appears on both Mr. Body individually and then as the registered agent for the corporate entity Making Away 7. Mr. Body filed an answer, but Breaking Away 7, Making Away 7 didn't file an answer, or if Mr. Body's answer was intended, it looked to me like it was straight up an answer by Mr. Body, but to the extent it was intended to in some way respond on behalf of Making Away 7, Mr. Body, unless you are an attorney, you're not allowed, only an attorney can represent a limited liability corporation or any sort of corporation in state court. And so, as I said, my review of the answer was that it was just for Mr. Body, but it wouldn't have been a valid answer on behalf of Making Away 7. And so because of that, it did not appear to us that there was an answer filed on behalf of Making Away 7. And so we directed the parties that we believed that Making Away 7 was in default, directed the plaintiff's attorney to file a motion for default judgment. And then in the interim, that occurred. There is a motion for default judgment, I think. There's a proposed order regarding final default judgment. But in the interim, there's also a summary judgment motion that was filed as to Mr. Bodie. Basically asserting that the judgment's already been entered in California and therefore it should be enforced. There's no reason for it not to be enforced. And so that's sort of where we are. Now, the main thing I know, given that Mr. Bodie is here, is that the summary judgment motion isn't actually ripe. It was just filed in the last 5 days. And so technically, if Mr. Bodie wished to, he would have an opportunity to respond to that substantively. So we're really just here today about Making Away 7. Although I was, in all honesty, a little bit surprised that it was referred to when I went back to prepare and make sure I understood what was going on in the case. To see that this was referred to as a petition on contract and account, because that's what it's entitled, which is why it's been handled procedurally by our office in the way it's been handled. But when I look at the substance of it, what it really is a petition to domesticate a foreign judgment. At least as I understand it. If it's not that, please explain to me, Ms. Bandel, if it's something different. But if it is a petition to enforce or domesticate a foreign judgment, then that would be even more reason. I mean, a lot of these processes didn't even need to happen, right? There could have just been an affidavit that said, we have a judgment, here it is. And, here's the last known address of Mr. Bodie. So, but nonetheless, I'm a big believer that service is better, right? To make sure you physically put it in their hand so they have an answer, an ability to respond and dispute if they choose to. So that's sort of where we are now. Is it Bandel? Am I pronouncing it correctly?
It is.
Anything to add, Ms. Bandel, to that sort of background?
No, you are absolutely correct. Just so you know, particularly in Fulton County, some of your colleagues are not accepting our filings with the affidavit for domestication and are requiring the petition. So I've just gone ahead on all of mine.
And I don't blame you, because I also am someone who's like, I understand that this process is allowed, but it feels like
I know
service wouldn't be a bad idea. But yeah, so I understand you have to, this is a more detailed response, arguably, than what is required under the statute. So
yeah, thank you. But yes, you have it all right.
Okay. Mr. Bodie, anything you would like to add, sir? First of all, let me ask, do you have an attorney for yourself or on behalf of Making Away 7?
No, I don't.
Okay. So as I said at the beginning, you as a non-attorney are not allowed to represent Making Away 7, but you are allowed to represent yourself. So is there any But let me say this regarding your representing yourself. There is a motion for summary judgment that has been filed. Have you received a copy of that, or were you aware of that filing?
When was that filed?
It was just filed on October the 25th, so just a few days ago.
No, I'm not with
Okay. It may be that it's in the mail on its way to you, and it just hasn't reached you, or it may be that if it was served by email, go check your email and make sure. But the reason I ask about that is that as I review this case, the only thing that is right for us to undertake today is the default judgment as to Making Away 7, who is not present. Because, Mr. Bodie, there is no attorney here representing Making Away, and Making Away did not file a substantive response to the judgment. Now, the reason I mentioned Mr. Bodie, if you have an email address, we're happy to email you that motion for summary judgment and the supporting documentation that Ms. Bendel filed if she hasn't already done it. And then what would happen is you would have an opportunity. The rule in Georgia is you get 30 days from the time of the filing of a motion to file a response. So if you wanted to file a response on your own behalf to that summary judgment motion that Ms. Bendel has filed, seeking to secure a judgment against you, then you would have an opportunity to respond to that before I would enter judgment of any kind.
Right. Okay.
Okay.
And Judge, if I may, I
Yes.
am always open to speaking with Mr. Bodie.
Mhm.
And I can give him my information because we always try and work these things out without the court's intervention. I just
Okay.
haven't heard from him. But if I may, can I confirm the email that we sent the
Yes.
documents? Is it rainmnfwr.jb@gmail.com?
Yes, ma'am.
Okay, and what I'm going to do, Mr. Bodie, is after the hearing, I'm going to send you an email so that we can open the line of communications and
Okay.
see, if we can, do something here.
Right. And
All
Mr.
right.
Bodie, I will tell you, I don't know anything about her client in this particular instance, but I have had Ms. Bendel appear before me before. And I've always, my experience has been with Ms. Bendel and other attorneys that work in this space that even when they get their judgment, they're still always happy to talk with people and try to see what can be worked out. So I encourage you to engage in that process if you think that it would be helpful for you, Mr. Bodie.
Yes, ma'am.
So, because this was essentially a petition to domesticate a foreign judgment, as far as I could tell, the damages were liquidated in terms of that $55,000 amount, which is the amount of the judgment. One question I had, you did file an affidavit of attorney's fees, but I was trying
Yes.
to determine the nature of those attorney's fees. Were they they couldn't have been 13,611. Are they 13,111? Or are they pursuant to the judgment in California?
No, they're pursuant to the action here, the
Pursuant to the
1,000.
contract?
Yes.
Okay.
And
And
then,
so
yes,
the reason I ask all those questions is because this is, as I understand it, a truly liquidated amount, right? The amount of the judgment is liquidated, and the amount of attorney's fees you seek is not pursuant to 13,611 or any other provision that would
right,
require the presentment of affirmative evidence on. I mean, we
right.
need to document it, but your entitlement to it is based on the contract and or the existence of the judgment. And so for that reason, I do have a proposed default judgment from you, Ms. Bendel, that seems to enter a final judgment against defendant Making Away 7 for the sum of $66,176.11, which is consisting of the $61,000. I'm generalizing from the default
Yes,
judgment, $2,800-ish in interest, $1,100 in attorney's fees pursuant to 13,111, and then $379.89 in costs, which I'm assuming would be the cost of filing the action and then
yes,
securing service to the sheriff. Is that right, Ms. Ben?
correct.
Okay.
Yes, Your Honor.
Mr. Bodie, it does appear that the default judgment would be, so to make sure you understand, under Georgia law, Making Away 7 is already in default, right? Because default is automatic on essentially the 31st day after the service of a complaint. So in this instance, Making Away was served back in August. And assuming it was on August the 7th, the answer would have been due, I think, on September the 6th, if I've done my math correctly. And when no answer is filed under Georgia law, that default is automatic, right? And then what here is happening is there is a 15-day opportunity for a party to open default as a matter of right, and that did not occur here. And so as far as the court can tell, legally, Balboa Capital is entitled to a default judgment against Making Away 7 in that amount that I recited just a moment ago. Do you have any questions, anything you would like to offer or add on that issue just as to Making Away 7, Mr. Bodie?
Yeah, the amount of this whole of everything, it seemed way off because in October of 23 that I requested a payoff amount, which was $46,000. And then it just jumped up to 58,000.
And I don't know the specific details of all that, Mr. Bodie, but I can tell you that my experience is that what will happen is, let's, if you have a judge, if you owe, say, 40-something thousand dollars, if the creditor ends up going through the legal process, they then ask the court to enter the principal amount they're owed, and they ask for interest, and they ask for fees, and they ask for costs. And that often ends up in a larger judgment amount than the amount you actually owed, because the contract says not only do you owe the amount you owe, but if we have to go to court to get it, then we're entitled to recover these amounts. And so oftentimes that will explain the differences, but I feel like if you are interested in talking with Ms. Bandel, that she would be able to walk through that process with you and help you better understand it.
Okay.
Okay.
I have an exact breakdown that I'm looking at that I'm going to email
Okay.
Mr. Bodie after this, and then we
Okay.
can start talking.
Okay.
Okay.
Anything else, Mr. Bodie?
Mm. And the 10% that they want for annually until this is taken care of.
That part I did not see, but I think that's something that Ms. Bandel is probably best able to answer. But I'm just not familiar with that aspect of it.
Yeah, that was the main things that I was just wanted some understanding before we, on my part, that was it.
I
mean, I'm
understand.
not denying the amount. I'm not denying that I owe.
Yeah.
But I just wanted to make sure it was accurate.
Yes, sir. I understand, Mr. Bodie, and you are certainly entitled to make sure that if there's an amount being enforced against you, that it is an accurate amount. So what I'm going to do today, Ms. Bandel, I see that you have filed your proposed final default judgment. If you could please email it, if you've not already done so, to Mr. Freehoff in Word format, so that I can edit it if it needs to be edited.
Sure.
And then Mr. Bodie, I'll just remind you, Ms. Bandel is going to send you, excuse me, Ms. Bandel is going to send you a copy of the motion for summary judgment that was pending. And that relates to you individually. So just so you're clear, the judgment that I'm entering today is as to Making Away 7, which I know I think is your company. But I do want to be clear that as of now, that judgment is not against you personally. It's only against Making Away 7. Now, separately, Ms. Bandel and her client have filed a motion for summary judgment on October the 25th. And if you wish to respond to that, you'll need to do so by November. And there's going to be a little bit of because of Thanksgiving. Let's see. So you would need to do that by November 25th. Yeah, I think your answer is going to be due on no later than the 26th, 27th, something like that. I'm not allowed to give you legal advice, but what I can tell you is that you have 30 days from when a motion is filed. Ms. Bandel is going to make sure that you have a copy of that motion. And so if you want to respond to it, you'll need to file something with the court, okay?
And you said that one is personally for me, just
Yes, sir. That's as to you individually.
okay.
Okay? Thank you,
Okay.
sir.
Thank
Thank
Both of
you.
Have a good day.
You
All right,
too.
you too.
Take